before you resume, Mr. Sims, I had a request from the Court of Appeal listing, which I imagine is from somebody watching on live now. Could counsel please speak up?
It's not been.
It's not easy.
It's not been the first time that's been said of me.
Oh, really?
I thought I was speing reasonably loudly today, I have to say, but I will try and speak loudly.
My experience of this court is that that side of the court is more difficult to hear from than this one, actually. I mean, I personally had no difficulty hearing you, just occasionally your voice dropped, but by and large, it was fine. So I think we'll just, I'm going to get my clerk to ask the building manager if he knows of any magic we might try and work. Don't feel obliged to shout, that's for sure.
Thank you. Well, my lords, I'm getting close to, I think, probably the buffers anyway, so far as my submissions are concerned. And there were just a few wrap-up points and points I just wanted to drill down in terms of the reasoning of the judge below.
Is there anything else you want to say about Lipkin-Gorman?
I think I've finished on Lipkin-Gorman. What I wanted to move now to was Singularis briefly, mainly because the judge seems to draw quite a lot from it in his judgment, and wrongly in our submission.
Yeah.
So if we can move to Singularis, which is behind tab 26 in the bundles, and the e-bundle reference is 969. Now, of course, the case will be familiar to your lordships. Again, it's in the corporate context of a company agency case. By the time we get to the Supreme Court, it's got nothing to do with the ambit of the Quince care duty as such, but all about questions of attribution and causation. And that's really what the case is about in the Supreme Court. But you can see in paragraph 1 of the judgment of the court given by Baroness Hale that there's a summary of what's been referred to as the Quince care duty of care. And if you may just briefly read that to yourselves. Now, what we would submit is that this recitation by the Supreme Court is not intended to suggest any different statement of principle from all the different statements of principle which we've been going through this morning. But for some reason, the judge appears to have drawn from this that in some way the so-called Quince care duty of care involves some sort of objective standard of dishonesty. And he seems to have drawn this from, I think, because Baroness Hale compresses slightly the way she describes the duty in this paragraph. If you want the paragraphs in the judge's judgment for the idea that he considers that really what this Quince care duty was involving some objective standard of honesty, if we go to the judgment, start with paragraph 82. And in particular, at the end of the first sentence, you see the word standards of honesty.
Yeah.
Is there any part of the judgment where the judge refers to the last bit of the sentence in the middle of para 1 of Singularis, which specifically stops talking about recklessness and starts talking about inquiry? Because I must say, off the top of my head, I couldn't see it anywhere, and it looked to me as though the judge hadn't even spotted. I mean, if he has spotted it, of course, I'd be delighted for you to show me.
Yes, I mean, of course, the whole point of the Quince care duty is it's got nothing to do with honesty or standards of honesty. It's about what further duties there are. I'm not sure is the short answer. I'll take you through the
Lady
paragraphs.
Hale's dealing with the two situations, isn't she? She's dealing with where the bank's actually executed,
Exactly.
as it were, dishonestly on the one
exactly.
hand, and where it refrains from executing, and there she's focusing on exactly what we're focusing on.
Exactly, and I think the mistake the judge has made is he's looked at her recitation through the sort of dishonest assistance type knowledge stuff, and then he thought that somehow that informed the bit at the end. That's how he seems to have read it, and we just say that's a misreading of the duty. And I think you not only get it from paragraph 82, but also paragraph 129. And it's the sentence following the judge's reference to singularis, starting words, the emphasis. The emphasis is upon liability where the bank is found to have fallen short of the much more general concepts of what is honest and reasonable.
Sorry, that was paragraph which of the judgment?
129.
Thank you.
Starting with the sentence, I think it's probably the penultimate, pre-penultimate sentence, but almost in the middle of that paragraph, the emphasis.
Yeah.
And then,
Yes, 'cause the previous sentence refers to avoiding being fixed with knowledge, which is not.
yeah, he's fallen into the same error, I think, that Lord Justice Parker warned against in Lipkin Gorman, basically. It's got nothing to do with probity or lack of commercial probity or any of that nature. And then 159 is another passage we picked up on. So this is where he's talking about two fundamental problems in support of the duty. Obviously, the first of paragraph 158 is the point about us elevating the duty so as to emasculate the primary mandate point, which I've already covered, I think. And the second is the point about, he says, I think it's in the second sentence, in the context of suspected misappropriation of monies, it is entirely appropriate to use the more general language directed at knowing or reckless disregard of commercially accepted standards.
Yeah.
So that's again making the same mistake. And then the last reference I had was 160, last sentence. That might not actually fourth sentence. So I do not accept the Quince code duty can be properly imposed to a higher set of standards which takes as a duty of care framed by concepts of knowledge, actual or constructive, rather than further negligence in failing to follow the rules of some code. So it's the sentence, it is a duty of care framed by concepts of knowledge, actual and constructive, rather than further negligence in failing to follow the rules of some code. And also the first sentence, standards of honest and reasonable conduct. So that's a further, in our respectful submission, error in terms of the way the judge approached it in the court below, which was influential in terms of his outcome, because I think it fed into his view, mistaken view, that this was all about some different test from the general duty that we've been describing.
Yeah.
So that was really the singularis point I wanted to pick up on just in the judgment. For our part, just so you understand it, we were seeking to make a point in relation to singularis, which we're not sure really whether necessarily the judge got, and it's probably my fault rather than his, which was, you may recall there's a passage in singularis, and I can take you to the specific passages, I think it's paragraph 16 and 23, where there's discussion about causation and the purpose of the duty. So the argument was being made on behalf of the appellant that knowledge of the fraudster should be attributed to the company, and the causative chain was broken by the dishonest acts of the company itself. And this is really has echoes of the Manchester Building Society point, I think, in this context, which is that what you need to look at is the purpose of the duty. Obviously, if the purpose of the duty is to protect the customer, then if the loss which flows from that purpose arises, then you can't turn around and say that that's a break of the chain of causation. It falls within the scope of the duty. I'd probably sort of dealt with that in a rather ham-fisted way, but I think you probably get the point I'm seeking to make. And
it's also striking in the context of singularis that if you look at what Sir Geoffrey Ross said in the Court of Appeal, at paragraph 86, in the previous tab of the bundle, he said that the scope of the Quince Code duty is narrow and well defined, and then but he then goes on to say it is to protect a banker's customer from losing funds held in the bank account with that banker whilst the circumstances put the banker on inquiry.
Absolutely.
So it's looking not at knowledge necessarily, but at what a reasonable banker would know in the circumstances, and it's also not framed, at least in his formulation of it, as referable only to situations where a corporate customer has been, or where the customer has been effectively defrauded by an agent.
Well, exactly, and that was the point we were seeking to draw out of singularis, because what we were saying is it's an odd situation for the law to arrive itself in, where the court rejects the proposition that even though an agent who the company is responsible for vis-a-vis the bank, that's not a reason to deny the duty or the causation is reject on that basis. But the personal customer is in a worse position. I mean, it probably still comes back to the question of what the duty is. This is really dealing with causation and attribution, so one needs to be a bit careful about taking too much from it. But it did strike us as odd, to say the least, that the law would end up in those very different situations. So I think that's probably all I need to say about singularis at this point then. If we then just go back to the judgment then and just a few wrap-up points in terms of the reasoning of the judge.
Yeah.
I respectfully concur with my Lord Justice Coulson's honing in on the paragraphs around, whether it's 131, I think it's before 133. But I was going to start at 128. And 129, and I think I've already made the point that this seems to be a sort of a key sort of mistake by the judge in terms of his analysis of the authorities and leading him to the wrong approach to conclude that this is all a question of law separate from negligence. So we say he made the mistake of treating knowledge akin to or associated with some sort of constructive knowledge principles or some of the Barden scale principles, made the same mistake which Lord Justice Parker warned against in Lippick and Gorman. And that's point number one. Point number two is paragraph 130, the suggestion that our formulation of the duties amounted to an extension of the Quince care and reference to amateur detective work, etc. Rather, this is the point, which is that, again, by reference back to the observations of Lord Justice Parker and Lippick and Gorman, those sorts of phrases are really examples of specific factual circumstances arising, and what one really needs to look at is whether or not normal banking practice did contemplate that they would be seek to prevent customer from the harm arising or not, and it may well be at trial that there's some argument about the precise way we formulated those duties, but it's not a reason to reject on a summary basis. Paragraph 131, I think I've dealt with this point already about in or about and the duty not just stopping when the bank presses the button on the execution of the transaction. And then a 132 and 133, I think we've already addressed the point about why we say that the judge was wrong to conclude as he did in these paragraphs that the authorities limit the duties to cases of attempted misappropriation by an agent. And I probably don't need to repeat myself in that respect. So that probably is sufficient for the purposes of this appeal, I suspect. But the judge then goes on and deals with the question of whether or not this is an extension, whether or not he should recognise it or not, etc. And I think I've already addressed you on his two main points against us in paragraphs 157 and it's 158 and 159. And briefly what we say is that paragraph 158 is simply wrong as a matter of law. So it's a sort of a misunderstanding of how the duties operate. And paragraph 159 is simply ignoring the fact that our test is postulated by reference to reasonable banking practice. And we don't understand how the judge could possibly have concluded at first instance that he had sufficient information on before him to conclude precisely what that was. If the bank succeeds at trial in showing that the standards or practices, reasonable standards or practices diverge from their own internal guidance notes or what the past says or whatever, then maybe, but on the material the judge had before him, it rather all pointed the other way. And the judge then, as another sort of key error we would respectfully submit, paragraph 153 is in our respectful submission, largely missing the point about the reason why we were relying on the materials we did. That was just simply in order to demonstrate to the court that we had a real prospect of showing that there was industry standards which reflected the development. And as I previously iterated, we're not relying on the code as such for the purposes of our claim. I think I've, of course, one might look at the PS, the Payment Services Regulators report and say there's no express recognition of any common law duty there, but naturally they're not necessarily focused on that because there's been no decided decision of the courts which has come before the courts in that respect. And secondly, the Payment Services Regulator in any event is primarily looking at regulation and legislation. At best, it might be said that passages in there might support an argument that was persuasive. But the Payment Service Regulator is not the court. They're not opining on whether or not there's a duty or not. And the passages which the judge referred to in relation to this, in our respectful submission, at best what they really simply say is that there are limits on what the bank can do because they can delay and delay, but there may come a point in time when they should pay according to reasonable banking practice. That's all really being said. I think I've dealt with the terms and conditions point. I think I've dealt with the rejection of the Brigden evidence, which we say, for reasons articulated, goes to both standards and duties. There's probably a blurring of those in this case in any event. And I suspect the other points, to the extent that the Muller friend seeks to support them, I can deal with in reply rather than troubling your lordships further right now. Of course, we maintain our argument that this is a mere subset of an existing category duty, but...
Talking of subsets, that reminds me, do you have a copy of your Venn diagram?
I will check.
Always welcome a good Venn diagram, but since the judge goes to the trouble of referring to it at paragraph 96, I was disappointed that it wasn't appended.
Yeah, we just assumed it'd be in your skeleton.
I think I screen shared it with the judge, actually. that's my recollection. I screenshot.
All right, well, if a paper copy of that comes to hand, I, speaking entirely for myself, would be interested to see it.
Or if you were able to reconstruct it for us.
I think maybe it was sort of the feeling of it not working once. Perhaps I shouldn't try a second time was what's going through my head. I don't know. But and can I say I think I broadly dealt with the main grounds I needed to, but to the extent I need to, I'll simply rely on the written case for the remainder. I don't think there's a need for me to move my application in relation to proposed ground 9, certainly not at this stage. And unless there's
There are enough grounds to deal with this.
Exactly, and I think my own friend, there's some valid criticism of the prolixity of the grounds on his part in relation to our grounds. I think there's one ground 5, which is talking about things after duty, perhaps to some.
But it might be said you rather overcomplicated the grounds of appeal. But I think broad thrust is.
You've got the broad thrust in any event. So, unless there's anything further I can assist you with.
No. Thank you very much. Thank you. Yes, Mr.
Lords, with your permission, I'll address you on the extent and the applicability of the Quince care duty, and as to various initiatives which would be relevant to the determination of ordinary banking practice. I'm not going to comment on the facts of this case. I think my client would want me to emphasise at the outset that the judge was mistaken in his view at paragraph 153 Roman 1 of the judgment, that which accepted when it made its super complaint in 2016 that banks were under no duty to guard against fraud where the payment was authorised by the customer. That wasn't Which's position, as Mr. Green says at paragraph 19 of his statement, which simply did not express a view in its super complaint as to the position of common law. Lords, there are 5 points I would like to make. The first is that the Quince care duty is an aspect or a subset of the general duty a bank owes to its customer to exercise reasonable care and skill. Lord Justice Coulson will recognise having identified that as Mr. Sims' 6th proposition. The second is that it would be illogical and unprincipled to limit the Quince care duty to cases where a corporate customer is defrauded by its agent. The third is that what the Quince care duty requires is calibrated by ordinary banking practice. No one is saying that what banks ought to be required to do is to take on onerous obligations that are alien to the needs of contemporary commerce. Fourth, that what ordinary banking practice requires has developed over time and was not fully taken into account by the judge below. And finally, although we share with Mr. Sims the primary position that the application of the Quince care duty to the facts of APP fraud is not an extension of the duty, even if it is, it would be fair, just and reasonable to recognise that the Quince care duty extends to personal customers who are victims of APP fraud. I think I can take the first 2 of those propositions relatively briefly because Mr. Sims has taken you to much of the relevant authorities. First, the Quince care duty is an aspect or subset of the general duty a bank owes to its customers to exercise reasonable care and skill. Mr. Sims took you to Lady Justice Rose, as she then was, in the Court of Appeal in Nigeria and JP Morgan Chase, paragraph 40, for that way of expressing the matter. The same formulation was used at first instance in that case by Professor Andrew Burrows QC, as he then was, at paragraph 21. That's page 396 in the electronic version of the authorities bundles. And my lords, as Mr. Justice Brightman said in Carrot, Rubber and Co., once banks are not seen as automatic cash dispensers, there is no rational stopping place short of a contractual duty to exercise reasonable care and skill, and that must rationally include, in appropriate circumstances, a duty to inquire before paying. And as Mr. Sims has indicated, going all the way back to Hilton and Westminster Bank in 1926, it's been a long time the case that a bank owes a duty to make inquiries before making a payment, if it's obvious a bank should do so. Turning then to the second point, it would be illogical to limit the Quince care duty to cases where a corporate customer is defrauded by its agent. policy considerations have shaped the Quince care duty. The decision taken by Mrs. Justice Rose, as she then was, in singularis, to allow recovery, despite the fact that the fraudster was the 100% shareholder of the claimant company, was expressly based by her on the need not to denude the duty of any value in the cases in which it was most needed. That's paragraph 184 of her judgment, at page 915 in the electronic version of the authorities bundle. But that passage is quoted with approval by Sir Geoffrey Voss in the Court of Appeal at paragraphs 56 and 57 of his judgment.
Hang on a moment. Let's just have a look at that. That's tab 20.
Tab 25 is the Court of Appeal. Which paragraph of Sir Geoffrey Voss's
It's
judgment?
paragraphs 56 and 57. You'll see it on page 2800 at D, where he quotes Mrs. Justice Rose, and then at paragraph 57, I says, I respectfully agree with this passage. And then it's quoted, the phrase is quoted more briefly by Baroness Hale in the Supreme Court at paragraph 35 in her judgment. So that's tab 26, and it's on page 1205 at F.
Yeah.
So one can see three eminent judges at each stage of singularis, although the question before them is attribution, the policy of not denuding the duty of value in cases where it's most needed is key to their reasoning. And Professor Andrew Burrows, as he then was in Nigeria and JP Morgan Chase, observed at paragraph 31, that's tab 13, That's paragraph 31. It's page 401 in the electronic version. It's 223 in the report. And it's at G. Sorry, it's 30 I want. He says there, to recognise such a duty of inquiry would be in line with sound policy. In the fight to combat fraud, banks with the relevant reasonable grounds for belief should not sit back and do nothing. And then he goes on and says the duty of inquiry would not be unduly onerous because it will always be limited by what an ordinary prudent banker would regard as reasonable inquiries. But if there's a good policy reason for encouraging banks to help combat fraud when companies are the victim, that policy reason applies even more strongly in favour of individuals, many of whom may be vulnerable. Now, my lords, it appears to be suggested on behalf of the bank at times that there's a distinction to be drawn between insider fraud and external fraud. But that distinction really breaks down. When a bank has reason to make inquiries, whether it was insider fraud or outsider fraud, may only be determined after the inquiries have been carried out, rather than in advance of making them. The distinction between companies and individuals also comes under some stress when one realises that individuals may act through agents as well as companies. My own friend Mr. Sims gave a couple of examples of the wife who is a sole account holder and her husband is the victim of fraud. Well, of course, there are many people, especially many vulnerable people, who have to operate their accounts through powers of attorney given to others. And it would seem illogical if the position is that if they are the victim of a fraud by their attorney, they might have the benefit of the Quince care duty. But if their attorney was defrauded, they would not.
Mr. As I understand it, one argument is that the difference is, in the agency cases, from the bank's point of view, what's wrong is that the authorisation itself is undermined, whereas that's not the case in APP fraud. Whatever the person who wants the payment to happen wishes, they do wish the money to be sent. So in that sense, it is an authorised thing, whereas with the whole point of these agency cases is all that what's going wrong is that the bank is in fact not really being instructed to do what it's being asked to do.
Well,
What do you say about that?
two responses. One is to say, as a matter of policy, that's the wrong place to draw the line, and I'll develop that in just a moment. But the second response is that in cases of APP fraud, the customer intends to make the payment, but does not intend the consequence of the payment. They've made a mistake. This is different in kind from the person who is intending to make an investment, and it turns out that the investment is utterly rubbish. Just to touch on the facts of this particular case, what Mrs. Phillips intended to do was to put her money in a safe account. It wasn't to release the money to the fraudsters. But the illogicality and unprincipled...
It might be said that both scenarios would respond to an inquiry, in the sense that if the bank is put on inquiry by something about the way in which the agent is seeking to operate the account, that's one thing. And likewise, if the bank is put on inquiry by something that the customer is doing, which suggests that this isn't really what the customer intends. In other words, Mrs. Philipp doesn't intend that to invest in some entity in the UAE. She's been misled into believing if she puts her money there, it'll be safe.
Yes, precisely. Now, the unprincipled nature of the distinction really, in my submission, could be most aptly stress-tested by reference to the facts of Lipkin-Gorman. So Lipkin-Gorman is at tab 12, and at page 353 in the authorities bundle, 1361A, one has there at the outset of Lord Justice Parker's judgment a description of the fraud that the solicitor with the gambling addiction committed, abstracting large sums of money from the client account. And at H, at the bottom of the page, Lord Justice Parker describes the three methods by which the money from the client account was abstracted. Cheques drawn to cash, cheques drawn in favour of a building society for credited to an account operated by CAS, and cheques drawn on the client's account in favour of the bank. What if, instead of abstracting the money from the client account, Mr. Cass had contacted the clients directly and asked them to make payments into a spoof account that he had set up? If that had been the method by which he had abstracted the client's money, it must be the case that the clients would have had a remedy against the bank if the bank had been on inquiry and failed to do anything. So thirdly, What the Quince care duty requires is calibrated by ordinary banking practice. The bank is required to act as a competent professional bank, not an amateur detective of the calibre of Lord Peter Wimsey or Father Brown. And your lordships have been taken to that passage by Lord Justice Diplock, as he then was in Marfani and Midland Bank, quoted by Lord Justice Parker at 137D and E in the King Gorman case, which simply states the obvious proposition. 1376D and E.
Yeah. Okay.
The obvious proposition, it must depend on current banking practice and change as that practice changes. And so we then come to the question of, fourthly, how has ordinary banking practice developed? Banks have, since the money laundering regulations 1993, been under an obligation to know the usual pattern of activity on the accounts of their customers and to monitor unusual transactions. That regime was strengthened by the Proceeds of Crime Act 2002 and is now well established. And your lordships have two versions of the money laundering regulations in the authorities bundle. At tab 38, you have the 2007 version. In the definitions clause, clause 2, there is a definition of occasional transaction, which means a transaction carried out other than part of a business relationship amounting to €15,000 or more. And then at regulation 5, you have obligations of customer due diligence measures involving identifying the customer, verifying the customer's identity, and then at C, obtaining information on the purpose and intended nature of the business relationship. At regulation 7, a relevant person must apply customer due diligence measures when A, establishing a relationship, B, carrying out an occasional transaction, which your lordship will remember is one from €15,000 or more, C, suspects money laundering or terrorist financing, or D, doubts the veracity or adequacy of documents. And the thing to note there is that those obligations are disjunctive. It's if any of these things occur, then customer due diligence measures need to be applied. And then at regulation 8, a relevant person must conduct ongoing monitoring of a business relationship, which means we see at 2A, scrutiny of transactions undertaken throughout the course of the relationship to ensure the transactions are consistent with the relevant person's knowledge of the customer, business, and risk profile. So there's built-in regulatory obligations in the 2007 regulations requiring banks to have in place processes for spotting unusual transactions. In the 2017 version of the regulations, the obligations move about in terms of numbering within the regulations, but are substantially the same. It's regulations 27. Yeah, your lordship will see that the threshold for occasional transactions now dropped to €1,000 in regulation 27. And then in regulation 28, the requirement to identify the company and assess the purpose of the transaction is at 28.2. And the ongoing monitoring is now at 28.11. Now, alongside those regulations, the FCA's systems and control standards have, since 2001, required banks to take reasonable care to establish and maintain effective systems and controls for countering financial crime. That's CISC 3, referred to by Mr. Green, paragraph 27B in his witness statement in the intervener bundle. But there is, at page 282 in the intervener bundle, a helpful timeline. 282. Showing other initiatives taken by banks to protect customers and stop fraud. And your lordships will see when you get to it the way in which the initiatives have evolved over time from 2002 through to 2019. And that includes, in 2017, the Banking Protocol for in-branch transactions. One thing omitted from that timeline is the industry-led code of practice developed through facilitation by the British Standards Institution, which came into effect on the 31st of October 2017. Mr. Sims did indeed steal some of my thunder in relation to that code of practice when he introduced it earlier. But can I ask you please to go to page 183.
So this is also 2017.
Yes, yes, comes into effect on Halloween 2017. Its terms and definitions begin at 181. But at 183 we have a definition of suspicious transactions. And your lordships will note underneath the definition there's a note in italics. A suspicious transaction could be a payment or a series of payments for an unusually large amount to a new payee. A transaction may also raise suspicions if it matches a known method of fraud. Your lordships were taken to various paragraphs within that code of practice. I don't want to repeat the references made by Mr. Sims, but can I please take you to 461, which is on page 189. And there, all frontline staff should receive training in indicators of risk, vulnerability, the organisation's customer fraud prevention strategy, and how to deal with fraud and financial abuse. And that reference to frontline staff, of course, is important. Your lordships will remember from the discussion in relation to Hilton, there was a question about what the bank manager would have done if he'd been asked and what the cashier ought to have done. My lords, in January 2018, UK Finance introduced its own best practice standards for banks and building societies responding to APP scan claims. And these already recognised impersonation scams as a rising trend in APP fraud. Those UK Finance standards were highlighted in a Dear CO letter sent by the FCA on the 31st of January 2018. And by March 2018, there was a body of Financial Ombudsman Service decisions setting a clear level of expectation as to how banks should be approaching the protection of their customers. Although the CRM code, which I think featured more below than it has in discussion before your lordships today, although that wasn't yet in effect till May 2019, the initiative which led to it had been proposed by the Payment Systems Regulator in November 2017. And the issues regarding the widespread problem of APP fraud were widely known and under discussion by early 2018, when in February of that year the steering group to develop the code was established. Now, my lord, 6 years ago, my client presented a super complaint on behalf of consumers. That appears in the supplemental bundle, and I want to refer to it briefly. I'm coming on to my final point, the reasons why it's appropriate to recognise the Quince care duties applying in favour of personal customers who are victims of APP fraud, even if that is, contrary to my primary submission, a development in the law. Well, if you have that supplemental bundle, the first page I'd like to take your lordships to is page 224. And it's the final paragraph.
Final paragraph on 224.
Yeah, final paragraph, especially the sentence, placing more liability on banks for the losses. Second reason appears on page 226. That's first bullet point at the top of the page. That without the recognition of such a duty, the risks relating to authorised push payments are not allocated to those best placed to manage them.
Where's that? 226.
226, first bullet point at the top of the page. And thirdly, though it may be regarded as a development of that second point, on page 232, again at the bottom of the page, banks who hold customer relations are, unlike consumers, able to develop systemic approaches and use their data to reduce risks from fraud. Such systemic approaches can be far more effective and efficient than individual consumer responses. My lords, the super complaint made by my client was made in 2016, 6 years ago. Some current measures do not cover international payments. Others are restricted to certain kinds of payment service providers. Current voluntary measures such as the contingent reimbursement model are delivering inconsistent outcomes for consumers. If your lordships wish to see that in diagrammatic form, that's at page 45 and 46. Page 46 in the intervener bundle, there's an indication of the different approaches taken by different firms. The Quince care duty as it applies to companies is a creature of common law. It's not a feature of the Companies Act. It's open to considerable doubt that Parliament would have found time to legislate for such a duty in favour of companies alone. What's proposed in our submission is the application of a historically well-recognised duty to what has become in very recent times a serious threat to the financial security of many ordinary people in the country. If it is not already part of the existing Quince care duty, applying it to APP fraud is precisely the sort of incremental development that it would be fair, just and reasonable for this court to affirm. Well, also, unless there's anything else I can assist with on behalf of the intervening party, those are my submissions.
No, thank you very much indeed, Mr. McElroy. Yes, Mr. Philipp.
My lords, my learned friend, Mr. Sibbons, has built quite a construct in his submissions.
in relation to which I will endeavour to show you there are no legal foundations. It's important to understand that this case is about one thing and one thing only. Was the bank under the duty for which the appellant contends? This case has nothing at all to do with standard of care or the standards of the banking industry. The bank says that the case does not even get there because the anterior question as to whether there is a duty in the first place falls to be answered in the negative. Now, it's important to recognise, because with respect to my new friends, this has been lost sight of this morning, that the banking sector is heavily regulated. And a bank performs all sorts of tasks in compliance with those regulations. Equally, a bank performs all sorts of tasks in compliance with obligations imposed on it by legislation, such as the money laundering regime. But none of that tells you anything about the legal duties that a bank owes to its customer. Now, with respect to my Lord Justice Coulson's observation this morning, this case was eminently well suited to an application for summary judgment. It gives rise to a short point of law, and if I may say so, the judge's reasoning, as I'll show you, was impeccable. No mini-trial took place, and no mini-trial need take place before this court. The judge simply took the claimant's pleaded case and decided, quite properly and rightly, that it was unsustainable as a matter of law. And what unfortunately has happened in this court is my little friend Mr. Sims has taken you to disparate parts of different areas of banking law and joined together various sentences to suggest that a certain answer is permitted. And with respect, as I'll show you, that is simply wrong. The bank says that the answer to this appeal is clear when seen in the context of three well-established principles of banking law. First, when the customer's account is in credit, the bank's primary duty, I stress the word primary, is to execute promptly the customer's instruction. If it fails to do so, the bank will be in breach of mandate and liable for the customer's losses. Second, the bank owes a subordinate duty to observe reasonable skill and care in and about executing the customer's instructions. The extent of that duty is to ensure that the customer's instructions are properly complied with. Has the bank transferred the correct amount to the correct account or on the correct date so as to effect payment in the manner instructed by the customer? In short, the service that the bank is providing is execution only, not advisory. And its duty is to ensure that the customer's instruction is properly executed. That is the limit of that duty. Third, and as a facet of that second duty, is the so-called Quince care duty. And if I may respectfully say so, my Lord Justice Birss this afternoon put the duty in its correct place. That is a duty on the bank to refrain from executing an instruction where the bank has reasonable grounds for believing that the instruction, and I emphasise the word instruction, is an attempt to misappropriate the customer's funds. Now, that duty can only arise in a situation where the instruction to the bank is given by a person who has been entrusted by the customer as an authorised signatory on the account. Because in other situations, like the appellants, there can be no issue about the validity of the instruction because it's been given personally by the customer. In other words, the Quince care duty is directed towards, and only directed towards, the bank taking care to comply only with instructions which have been properly given and authorised by the customer. And framed like that, as the judge said in paragraph 165, the Quince care duty exists in reasonable harmony with the bank's other duties. Now, these three principles are well supported by numerous authorities. Indeed, they are indisputable. And there is not, in fact, a single case that supports or comes close to supporting the rewriting of any of these well-established duties in the manner contended for by my learned friends. Indeed, the position they advance would drive a coach and horses through the well-established principles applicable to a banker-customer relationship and the carefully structured duties to which that relationship gives rise. It would, and I don't make this submission by way of interiorum, it would have severe consequences for the banker-customer relationship. So let me make these points good. So starting then with the first principle, the bank's primary duty is to execute promptly its customer's instruction. Now, I don't understand there to be any issue between the parties in relation to this duty, subject to one point I'll pick up in a moment. And the classic statement here is the statement by Lord Atkinson in the Hilton case, which is at Authorities, Volume 2, tab 31. Page 126 of the report, we see the start of Lord Atkinson's judgment, and he sets it out right at the beginning. My lords, it is well established that the normal relation between a banker and his customer is that of debtor and creditor. But it is equally well established that the code of the drawing and payment of the customer's cheques as against money of the customers in the banker's hands, the relation is that of principal and agent. The cheque is an order of the principals addressed to the agent to pay out the principal's money in the agent's hands, the amount of the cheque to the payee thereof. So the position is very clear. When the account is in credit, the bank is obliged to comply with its principal's order. And any failure to do so will place the bank in breach of mandate and liable for the customer's losses. Now, the one point of difference between my learned friend and myself here is this rather peculiar passage in Paget, paragraph 2251, which suggested somehow that the bank wouldn't be in breach of mandate if it didn't pay out, unless it was acting negligently. That is simply wrong as a matter of law, and there's no citation linked to that sentence. It's wrong. I can show you it's wrong in this same judgment. If one goes back to page 126, to the end of Viscount Dunedin's judgment, in the top right-hand column, the second full paragraph down, he says, "It must always be remembered that a bank can be sued just as much for failing to honour a cheque as for cashing a cheque that had been stopped. And then the point is even clearer in Lord Shaw's judgment on page 129. The first paragraph there on the right-hand side is that, my lords, I concur, the case has reference to the stoppage of a cheque of a particular number, name, date and amount. When a banker is in possession of sufficient funds to meet such a cheque from a customer, the duty of the bank is to honour that cheque by payment, and failure in his duty may involve the bank in serious liability to its customer. And then over the page, the same point comes through in Lord Wenbury's judgment, halfway down the right-hand column, where he just says at the end of that first full paragraph, had those been the facts, and had the bank dishonoured the second cheque, they would have been liable to an action.
So where are you? You're on page...
Page 130,
Yeah.
in the right-hand column,
Yeah, got there too.
about halfway down, just at the end of the second full paragraph, had those been the facts. So the passage in Paget, or that sentence, is just simply wrong. I mean, it's clear as a matter of law, and it's been clear for centuries as a matter of law, that if a bank fails to comply with the mandate, it is in breach, and it is liable for the customer's losses. Now, my little friend this morning placed quite a lot of reliance on this Hilton case. This Hilton case doesn't assist this court at all in answering the question as to whether or not there is the duty for which he contends. And that is because this Hilton case is all to do with whether or not the bank complied with the instruction. It's got nothing at all to do with the question whether the bank was on inquiry. The question was simply, the customer gave the bank an instruction, did the bank comply with it? In other words, it's absolutely classic application of the second duty.
If the bank was in, just assume for the sake of argument that the bank was on inquiry, but there was something unusual.
My lord, one must be very careful when one uses that expression on inquiry, because the on inquiry question here is, was the bank on inquiry as to which cheque the customer actually was stopping?
Let's take the facts of this case, right? Mrs. Philipp goes into the bank, with or without her husband, doesn't matter for present purposes. There's a series of questions posed by the relevant lady in the bank, sitting in her little office to the side or wherever it was, about the amount of the money involved. And let's assume for the sake of argument that Dr. and Mrs. Philipp appear to be rather flustered by the question. And let's assume that the bank employee thinks there's something very odd about this. I don't think they're necessarily giving me the full picture. I'm concerned that they may have been the victims of fraud. Are you saying that in those circumstances the bank should just pay and isn't under any duty to pause and to delay for a short period of time?
Well, this comes back to the question I posed at the beginning, which is duty to whom? That the bank has a whole plethora of regulatory and legislative obligations. If the bank thinks there's money laundering going on,
Not money laundering, but fraud on the customer.
well, if the bank obviously, or the manager is concerned that that the bank wouldn't be complying with its regulatory obligations, then plainly it wouldn't act inconsistently with those. But that doesn't tell you anything about the question of the legal duty.
I don't think you're answering my question with respect, Mr. Goodall. This form of fraud has become prevalent, quite prevalent. I mean, I agreed it wasn't as prevalent in March 2018 as it is in February 2022. I mean, speaking for myself, I had a text message from my bank only at lunchtime today warning me about APP fraud.
Yes.
But it was still prevalent. And the point I'm putting to you is assume that the relevant bank employee who interviews them has cause to suspect that they've been the victims of APP fraud. Are you saying that the bank is under no duty to do anything other than make the payment?
No, I'm saying under no legal duty to the customer, but that's different to the question the bank might be under as a matter of regulation or legislation. That's the point I'm making. That's
There's no duty to the customer in those circumstances whatsoever?
No. Now,
So I assume the same answer would go to the question I put to Mr. Sims this morning. If something came up on the screen that said Lambie Petroleum under investigation, or something, then again there would be no duty to do anything about it.
well,
No duty to the customer.
yes, I mean, obviously the bank wouldn't be paying in those circumstances because obviously there would be concern about there being money laundering.
Well, that would depend on the facts.
Well, it depends what, of course,
That assumes compliance. I'm just trying to explore the duty, this being a simple, straightforward strikeout. There would be no duty to the customer to pause if it was a red light in relation to Lambie.
the bank would pause in that situation because of its regulatory obligations.
One would hope so.
But what the point I'm making, my lord, is that the duty, the legal duty,
There would be no duty and no breach.
no legal duty to the customer.
To the customer.
The-
So
the-
the bank might be in breach of its regulatory duties so far as the FCA or whatever is concerned, as my lord put to you, but it wouldn't be in breach of any duty to the customer.
And all that, and that's been that position has been held consistently by the courts. I mean, for example, the Green and RBS case, the Court of Appeal said yes, the bank owed duties to the regulator under its.
Yeah.
That doesn't give rise to a duty vis-a-vis the customer. That's common. I may respectfully say so. That the bank owes lots of duties to the regulator, which are not actionable by the customer. And indeed, the whole FSMA regime is premised upon that because the SA handbook itself has a whole plethora of duties, some of which are identified as being actionable by a customer, others of which aren't. And so, for example, my learned friend Mr. McElroy referred you this afternoon to what he called the Sykes obligations, prevention of fraud. Those are provisions of the SA handbook which expressly provide that they're not actionable by the customer. Maybe just to show you that while right, that's in tab in Authorities Volume 3 at tab 42. So tab 42 has the chapter 6 of the Sykes part of the handbook, the Sykes source book, and we see 6.3 on the second page, financial crime, and there's a whole load of obligations here on banks, including having policies and procedures to identify, assess, monitor money laundering, and so on. If you then go on to the next divider, tab 43, this is also part of the SA handbook, Schedule 5 to the Sykes source book, to Schedule 5.4G at the foot.
Sorry, which page are you on, Mr. Goodall?
On tab 43, the first page behind tab 43.
Oh, yeah, sorry.
At the foot of that page, we see Schedule 5.4G, and on the right-hand side of that table, we see the heading at the top, right of action under section 138D, and then you see beneath that a series of notes.
Right.
So here's a good example of where the bank owes all sorts of regulatory duties to the FCA, including having these systems and policies in place, but they don't give rise to any right of action on the part of the customer. And the Court of Appeal in a case called Green and RBS, which we've got in the bundle, it held that in a situation where there's no right of action on the part of the customer under FSMA, there's no concurrent common law duty of care because that would be inconsistent with Parliament's intention as to how those duties should be enforced. Coming a little bit away from where I was, which was on this first duty to being the primary duty to execute promptly the customer's instruction, and this common law obligation on the bank has in fact now been enshrined in the Payment Services Regulation, which specifies that the general rule is the bank must ensure that the payment is credited to the payee's account by the end of the business day following the payor's instruction. And I'm going to come on later to say a bit more about the payment services regulations, because there's some significance. I can see that my Lord, the Chancellor, is looking for something. Can I assist, my Lord?
Don't worry. I'm just clarifying. I was actually wondering about Paget.
Paget's a volume 3.
I know, but what I was wondering was how long that passage had been in the textbook for. Has anybody looked into that?
I personally haven't. I suspect we can try and do that overnight.
There's a case cited called Royal Products and Midland Map.
We've got that in the bundle, and in fact that doesn't support it either.
That's Miss Justice Webster's case.
Right, that's in the bundle. That doesn't support the proposition. There is no case of which I'm aware that supports the proposition that a bank can act in breach of mandate and not be liable to the customer. I mean, it would be a surprising proposition if that.
Yeah, I mean, subject to the point that I put to you, which you obviously need to think about. I see considerable force in that point, but I'm not sure it's necessarily the case if the bank's put on inquiry that something fishy is going on. Even if it's not just money laundering.
I mean, to be clear, I am not suggesting, and I'll just be quite clear about this, I'm not suggesting the bank can see or be told something and just ignore it. I mean, as I say, there's a whole regime here.
Well, that's the point, though, you see. And in a sense, this comes back to the point that we put to Mr. Sims at the beginning of the day. What troubles me, at least, is really you may very well be right in the submission you make as to the bank not owing a duty on the facts of this case when the matter's been fully explored at trial. But what troubles me is that because there are gradations, because there may be a situation where the bank is sufficiently on inquiry that it does owe a duty to at least pause, not just proceed, then that's something that can only be investigated after trial.
Well, with respect, there's nothing that can emerge at trial that will bear upon this question. The judge took the claimant's pleading. He took it and said, I'll take that as being established at trial, and it doesn't pass muster. There's nothing that would emerge at trial that could bear upon the question of the existence of the duty. Because it's just not legally coherent, for reasons I hope by the end of my submission you'll agree with. It just doesn't fit with the structure of the duties the bank is under. Because, and this is the critical thing, that the bank is the customer's agent, and its role is to do what the customer tells it to do. And the real question is, and this is where Quince comes in, is to establish whether actually what somebody else on behalf of the customer is telling it to do, whether that really is the customer's instruction. And that's why Quince is all about, and only all about, what we have termed, and some other cases I'll come on to have termed, an internal fraud. In other words, a fraud by the authorised signatory on the customer. It's got nothing at all to do with an external fraud. It's somebody sitting outside that bank-customer relationship. There's not a single case that supports that. And in fact, on the contrary, there are three cases I'll show you, which expressly, two of them expressly hold that Quince has no application to an external fraud. Mm-hmm. So that's the first duty, the primary duty to comply. That then brings me on to the second duty, the duty on the bank to observe reasonable skill and care in and about executing the customer's instruction. Now, the important point here is the one I've already made, and that is that the service, to use the language of section 13, the service being provided by the bank in relation to a transfer is execution only. But by definition, the bank is not a party to the transfer. It's not the payor, it's not the payee. It's executing its principles, the customer's instruction. Now, I just want to show you one authority in this context, and that's the decision of Mr. Justice Saville in the Redmond and Allied Irish Banks case. That's Authorities, Volume 1, tab 16. Perhaps if my lords could be kind enough just to glance at the facts in the heading, in the head note. Don't worry about the whole, just the facts, just to get the context. And then we can pick it up at page 310 in the report. In the bottom left-hand corner of page 310, where Mr. Justice Saville says, this is just beneath the marking line 40, there is clear authority for the proposition that a bank owes its customer a duty to take reasonable skill and care in, and I'll ask you to underline those words, interpreting, ascertaining, and acting in accordance with the instructions of the customer. And there's then a reference to Selling-Law and Carac Rubber. And in fact, that triumvirate, interpreting, ascertaining, and acting in accordance with, is actually the language of Mr. Justice Ungo Thomas in Selling-Law at page 1609C. So that's the ambit of it. Interpreting, ascertaining, and acting in accordance with. It's not, to use my Leonard Franz language, anything reasonable the banker considers, anything a reasonable banker considers appropriate. That is not the duty. The duty is to understand what the customer's asked you to do and then do it. And then on we go. Mr. Wallace admitted in the present case, the circumstances were such that duty required a bank to give a warning or advice about the risks in dealing with such checks. But in my judgment, this is not so. I agree with Mr. Hatley on behalf of the bank, who submitted that a duty to take reasonable care in interpreting, ascertaining, and acting in accordance with the instructions of the customer is something wholly different from the duty suggested by Mr. Wallace in the present case, which is to warn against or advise on the risks inherent in carrying through that which the customer wants to do. In my view, the banker-customer relationship creates no such duty, nor was any such duty created by any of the circumstances on which Mr. Wallace relied. Of course, if a customer seeks advice or is voluntarily given advice, then other considerations might well apply, as would be the case where any special fiduciary relationship arose, as in Lloyds Bank and Bundy. In a case such as the present, however, I see no basis for a duty to advise or warn a customer that there are risks attendant upon something which the customer wishes to do. Such a duty, unlike the duty held to exist in Selling-Law's case, is not required to give efficacy, I'll stress that word, efficacy, to the contractual relationship between the parties. So, as I say, the duty, this second duty, is concerned and only concerned with the proper execution of the instruction. It doesn't give rise to any advisory duty on the part of the bank. And in fact, we can see that if we look at Paget and the examples of cases that have arisen in which this duty is said to have been broken. And that's in Paget, volume 3, tab 45. And perhaps if I could ask you to read at the foot of page 23, Paget, be kind enough to read paragraph 22.54. So all these examples and the cases cited here are all directed towards ensuring that the bank accurately implements the customer's instruction. And in this appeal, there is no dispute that the bank accurately executed or implemented the appellant's instruction. That the bank did exactly what the appellant instructed it to do. It transferred the correct amounts to the correct accounts in accordance with her instructions. And her complaint is not about the bank's execution of the payments. That the payments were made to the accounts she wanted in the amounts stipulated. So this duty cannot provide a basis for the appellant's arguments on this appeal. It is untenable to suggest that the bank has breached it. So that then brings me on to the third principle, which is the Quince care duty. Now, the Quince care duty is a duty on the bank.
Sorry to interrupt you. On your submission, if I've got it right, because you're going to go on to say Quince care doesn't apply in these circumstances, that's it.
Correct.
You say the duty is only as to the execution
Correct.
of the instruction, and there can't be any complaint about that. So that's the end of it.
Correct.
And so, and you say that would therefore justify an application to strike out.
Yeah.
So although you're going on to deal with Quince care, actually it's to say it doesn't apply.
Yes, and I've got a lot more that's going to come after that to show you why the case can't be right as a matter of, well, A, as a matter of precedent, and B, as a matter of policy, as a matter of practice, and indeed consistent with the payment services regulations.
I'm sure that there's plenty more to come, but just in terms of your three principles that you helpfully started with, and Quince care is the third, the slow-witted like me need to understand that you're dealing with Quince care, but in fact your primary point is it doesn't apply at all.
Correct. Now, there's
Which would then take us back to the end of your second point being that's it.
correct. I mean, I sensed that this morning that the panel very much saw this case as being a breach of that second duty, as I've called it. That is not this case, and certainly if that's the road the panel wanted to go down, that would certainly be quite a fundamental change in how that duty's been understood. My name is
We might
Mr.
not go down that road, we might go down the middle road, which is the one that I was putting to you, which is that we might say that whether or not there was a duty and whether or not the breach should be determined at trial.
Well, with respect,
I mean, I follow your submission that there's nothing in this, so it should just stop where it is.
correct.
And if you're right about that, well, then you're right about it.
And with respect to my lord, one needs to be very careful about what you described as the middle road, because if one wants to go down that road, one has got to be intellectually honest, if I can use that expression, as to why you're going down that road. And the only way one can go down that road is to identify some arguable duty. And that, I'm afraid, is not open on the law. And the problem with going down that road, if I may respectfully say so, is one can only imagine what would happen in the county courts with customers making all sorts of allegations about what the bank should or shouldn't have done about some transaction they wanted to perform, which then goes wrong. So one needs to be very clear as to what it is that middle road involves and how it is you are intellectually getting there, because I would, with respect, suggest there is no room for the middle road.
Mr. Goodall, speaking for myself, it's no secret that I didn't practice at the bar worrying about duties of care very much. Neither of you have done is addressed what we haven't done because they're elementary to you, what the principles are for answering the question of whether a duty of care exists at all. And because it's, at least from where I'm sitting, it sounds like it's capara indictment, but I don't know. You'll need to tell me. But also, it'll at least go this far. The fact that no one has ever said there was a duty of care in a particular case can't be the end of the inquiry, because I know there are principles that decide whether you should say there's a duty of care in a case, and no one seems to have told me what they are.
My lord, and there's a good reason for that. If I may say so, you've respectfully hit the nail on the head.
Okay.
This is not, and my known friend does not suggest it is, a capara indictment case.
All right.
He is not arguing for a capara indictment type duty. And I'll deal with all this tomorrow morning. But he doesn't suggest, and he couldn't suggest, that there's been some assumption of responsibility on the part of the bank. That's not his case. His case is as simple as saying, either I can get in through the second duty, brackets you can't, or Quince care should somehow be evolved or developed to cover my circumstance. He's not contending for a caparo duty. And that actually is very significant when one comes to look at the case law on what has loosely been labelled incremental development. Because all those cases are concerned with a duty of care properly so called. That's not this case. Now, just going back to my Lord Justice Coulson's question, the caveat, as it were, is, as I understand my learned friend Mr. Sims, he is saying, I think, effectively, I can get myself within the second duty. Mr. McElroy, I think, is taking a different line. He is saying, this is Quince care. And then his sixth and final point was, if it's not Quince care, it's sort of Quince care plus, and you can get me there with a bit of a nudge. Yeah. So I think they are running slightly different arguments, but certainly on Mr. Sims's argument, I would say you finish at duty 2, game over, and Mr. McElroy, I'd say Quince care is on a totally different part of the pitch. And the other point I'll make is that the Quince care duty itself, as properly framed, tells you a lot about the second duty. So once you actually understand what Quince care is about, it tells you what the second duty is about, i.e., have you properly understood the customer's instruction? Have you ascertained it? Have you interpreted it, to use the language of Mr. Justice Salmon? And if I may say so, Lord Justice Birss was correct when he put to Mr. McElroy what the Quince care duty is all about. That's it. It's all about understanding the instruction. And that's why it's a facet of the second duty. And once you see it as a facet of the second duty, it is impossible, with respect, for the duty to arise in a situation where the customer is an individual. Because there can be no doubt when an individual gives an instruction to the bank that it is his or her valid and proper instruction. And the duty can only arise where the customer is operating the account.
Well, it could operate. It could arise. Strictly speaking, it could arise in the case, for example, of a fraudulent attorney.
Correct. That with respect, is right.
It could arise in situations where the individual customer is acting through an agent.
Correct.
Your point is that where it's the individual customer,
Correct.
him or herself, then that's.
And I've been careful to say, I've been careful to, as it were, use the language of authorised signatory.
Yeah.
So if in my law's example, the attorney does have the authority on the account under the mandate, and if that attorney is acting in fraud of the customer, then it can apply. It's an internal fraud. Where it cannot apply is on an external fraud. Now, I want to start with Quince itself, because my own friend this morning has just jumped over at great speed all these cases, and we need to actually look at them and see what's being decided, because that's obviously pretty critical. So this is Authority Volume 1, Tab 3. Now the facts in this case were relatively straightforward. The chairman of Quince, being Mr. Harry Stiller, caused about £340,000 to be transferred out of the company's account, which he then misappropriated for his own purposes. And Quince Company alleged that the bank, in executing the order to transfer that money, was put on inquiry that Mr. Stiller was acting for his own benefit and for an unauthorised purpose. And we can pick it up at page 374, which has the heading about halfway down, the alleged breach of duty by the bank towards Quince. And then we see Quince's propositions of law. On behalf of Quince, the following propositions of law were advanced. 1, there is an implied duty of care in the customer-banker relationship. 2, if the circumstances are such that they would raise questions in the mind of a reasonable banker as to whether the transaction was in fact truly authorised by the customer and for the customer's benefit, then the bank is under a duty of inquiry. So the inquiry is, as it were, tied to whether the transaction was in fact truly authorised by the customer. And then 3, if no inquiry is made, then negligence is established. 4, the quantum of damages is for the loss suffered as a result. And we then see Mr. Justice Steyn refer to Selingore and Karak rubber. And I think we can jump over that for the moment. I'll come back to those cases later on. And then at 375, just below the letter D, he refers to Lipkin-Gorman and the decision of Mr. Justice Alliot. Just pausing there, Mr. Justice Alliot's decision preceded Mr. Justice Steyn's decision in Quince. The Court of Appeal came later.
Later the same year.
Correct. He says, in Lipkin-Gorman, Mr. Justice Alliot considered what a bank's relevant contractual duties are towards a customer. He held the following propositions to be established. 1, the bank is entitled to treat the customer's mandate at its face value, save in extreme cases. 2, the bank is not obliged to question any transaction which is in accordance with the mandate, unless a reasonable banker, and I'll ask you to underline these words, would have grounds for believing that the authorised signatories are misusing their authority for the purpose of defrauding their principal or otherwise defeating his true intention. So it's the use by the authorised signatories of their authority that is the relevant touchstone. In other words, the so-called internal fraud. 3, it follows that if a bank does not have reasonable grounds for believing that there is fraud, it must pay. 4, mere suspicion or unease do not constitute grounds are not enough to justify a bank in failing to act in accordance with the mandate. 5, a bank is not required to act as an amateur detective. And then Mr. Justice Sain says, while I found this approach instructive, the importance of the matter warrants an independent examination of the bank's duties. And then he then goes back to effectively where I started with Westminster Bank and Hilton. We see that below H. Primarily, the relationship between a banker and customer is that of debtor and creditor. And then he cites Westminster Bank and Hilton, the book we've looked at, Lord Atkinson. Similarly, where the bank in the present case acted on an order to transfer by immediate money transfer money from the Quince current account to Philipp Evans & Co in Bournemouth, the bank was acting as Quince agent. As agent, the bank owed fiduciary duties to Quince see Balsted. Prima facie, every agent for award is also bound to exercise reasonable skill and care in carrying out the instruction. I'll stress those words, carrying out the instruction, again, is execution of his principle. That there is no logical or sensible reason for holding that bankers are immune from such an elementary obligation. In my judgment, it is an implied term of the contract between the bank and the customer that the bank will observe reasonable skill and care in and about executing the customer's orders. And then when we get down to letter C, given that the bank owes a legal duty to exercise reasonable skill and care in and about executing a customer's order to transfer money, it is nevertheless a duty which must, generally speaking, be subordinate to the bank's other conflicting contractual duties. Ex hypothesi, one is considering a case where the bank received a valid and proper order, which is prima facie bound to execute promptly on pain of incurring liability for consequential loss to the customer. So again, there's the point about liability to the customer for breach of the mandate. However, how are these duties to be reconciled in a case where the customer suffers loss because it is subsequently established that the order to transfer money was an act of misappropriation of money by the director officer? So he's looking at the whole thing through the prism of internal fraud. If the bank executes the order, knowing it to be dishonestly given, shutting its eyes to the obvious fact of the dishonesty, or acting recklessly and failing to make such inquiries as an honest and reasonable man would make, no problem arises. The bank will plainly be liable. But in real life, such a stark situation seldom arises. The critical question is, what lesser state of knowledge on the part of the bank will oblige the bank to make inquiries as to the legitimacy of the order? I'll stress those words, legitimacy of the order. In judging where the line is to be drawn, there are countervailing policy considerations. The law should not impose too burdensome an obligation on bankers, which hampers the effective transacting of banking business unnecessarily. On the other hand, the law should guard against the facilitation of fraud and exact a reasonable standard of care in order to combat fraud and to protect customers and innocent third parties. Now, just pausing there, I would underline the word innocent. Innocent third parties. That is not a situation that arises in relation to an APP fraud. There's not an innocent third party. The payee, by definition, is a fraudster. To hold that a bank is only liable when it has displayed a lack of probity would be much too restrictive an approach. On the other hand, to impose liability whenever a speculation might suggest dishonesty would impose wholly impractical standards on bankers. In my judgment, the sensible compromise, which strikes a fair balance between competing considerations, is simply to say that the banker must refrain from executing an order if, and for as long as, the banker is put on inquiry in the sense that he has reasonable grounds, although not necessarily proof, for believing that the order, again, I'd ask you to underline those words, the order is an attempt to misappropriate the funds of the company. And he then refers back to the proposition that Mr. Justice Elliott has set out. Now, I would respectfully suggest, let me just pause there. That passage at G, the put on inquiry bit, that is the Quince duty. So refrain from executing an order if and so long as the bank is put on inquiry for believing that the order is an attempt to misappropriate the funds. So that's the Quince duty.
Why doesn't that apply in this case?
Because
In this case, it is. The order was an attempt to misappropriate. multiply the funds of the customer.
But with respect, Lord, that's not right. The order was a valid order. It was an instruction to do what the customer wanted them to do.
Well, I know you say that, but I'm looking at the words of the judge in this case, and it doesn't seem to me that there's anything inappropriate about reading the order is an attempt to misappropriate the funds of the company. The company is obviously the customer. And why is that just exactly the facts of our case?
Because the
this
whole-
order was an attempt to... I mean, I understand you say it's a valid order, but then this whole thing is ex hypothesised a valid order.
No,
So
but my lord,
why isn't it an attempt to
With respect, he's talking, if you look at E, about the legitimacy of the order.
Well, I understand that he is in the facts of his case. What I'm putting to you is that the logic here, I mean, clearly this case was about a case in which the order was by an agent, and the fact that, and therefore if it was vitiated by fraud, the order wasn't a valid order. I mean, I get that, that's obviously what this case was. What I'm putting to you is that the thinking and the language, although it was based on that factual situation, why doesn't it apply to this case?
Because, my lord, this Quince care duty is itself a facet of the second duty. And that second duty is all about properly executing the customer's instruction. And what Quince care is then focusing upon is, has the instruction that has purported to come from the customer, is it actually legitimate? In other words, is it an instruction the customer really wanted to give?
Why can't you say, isn't it an attempt to misappropriate the funds of the customer?
Be-
Why can't you phrase the question that way when all I'm doing is reading the way the judge and that
Because, my lord, he is talking and only talking about, in the context of the reasonable skill and care and about executing the instruction, he is talking about the legitimacy of the instruction. Is it a legitimate instruction? In other words, is it an instruction that the customer itself actually wanted to give, or is the authorised signatory off on a frolic? So it's impossible with respect, my lord, for this to arise other than within the order. That's why it's critical that he's talking there on a number of occasions, both at E and at G, about the order.
I'm just at D. How are these conflicting duties to be reconciled in a case in which the customer suffers loss because it is subsequently established that the order to transfer money was an act of misappropriation of money?
Yes.
Which it was.
No, but sorry, an act of misappropriation by the director or officer.
I know. I deliberately stopped because
respect,
why
my
does
lord-
it matter?
But
Why does it matter?
My lord, with respect, you can't skip over words. That's what my learned friend's been guilty of.
My lord is saying, why does it matter as a matter of principle, this being a strikeout? Whoosh, cut off, nothing else, strikeout, no claim. What my lord is saying, how can we get a general principle in relation to the specific facts of this case? Of course it's talking about the fraud by the director or officer, because that's what the facts of that case was about. The facts of this case are different, but the underlying point is, why should the same principles not apply?
Because, my lord, when you put Quince care in its proper context and understand it's about the execution of the instruction, it's just simply a facet of the question: has the bank properly interpreted, ascertained, and acted in accordance with the instruction?
Well, it does beg the question. I think that's both my lords putting to you. It does beg the question as to the legitimacy of the instruction.
Yes.
Because on the facts of this case, the mind of the customer was suborned or whatever by the fraudster. So in truth, the instructions that the customer was giving were not in truth what she really intended. They're not what she wanted, and they certainly were not for her benefit.
But, my lord,
And the question then is whether it's an extension of the Quince Care, not Chris Close, but Quince Care duty, or is it a facet, as I think Mr. Sims put it, as it were another sub within the overall duty. Anyway.
I hope by the end of this, once I've taken you through all the cases, you will understand.
Yeah.
The position.
I'm sorry, we're putting a lot of points to you, and we must let you make your submissions.
There are a number of cases where it's been made very clear that Quince care can only arise in a situation where there's, to use my language, an internal fraud. Equally, least two cases where it's been expressly held that it can't apply to an external firm. And as I say, the important point is the order legitimate from the bank's perspective? In other words, has the bank got reason to think that the authorised signatory is acting in fraud of the customer? Is it an order the customer really wanted to give? Now that then takes us to Lipkin Gorman at tab 12 in the Court of Appeal. Now I'm sure you're very familiar with the facts of the case, but just to restate them briefly. Mr. Cass was a partner in the solicitor's firm Lipkin Gorman. Lipkin Gorman banked with Lloyds Bank, and the mandate provided that any one of the partners was an authorised signatory on the firm's account. And Mr. Cass was a gambler, and he drew on the account to fund his gambling. And Lipkin Gorman brought various claims against various people, including the club, and also including against Lloyds Bank for dishonest assistance and for breach of contract. And the first instance judge, Mr. Justice Elliott, found that the bank was liable as constructive trustee, although that was then subsequently overturned by the Court of Appeal. And the short point in relation to this case is that, again, the decision is concerned only with a situation where the authorised signatory is acting in fraud of the customer. And the duty of inquiry to which the court referred was in relation to whether the authorised signatory was misusing their authority for the purposes of defrauding their principal, i.e. the customer. Now, Lord Justice May's judgment appears first, although I think it's right to say that strictly he was not in the majority because Lord Justice Nichols agreed with Lord Justice Parker, although certainly Lord Justice May's judgment seems to have got traction along with Lord Justice Parker's in subsequent decisions. And we can pick it up at 1352, where at the foot of that page, Lord Justice May says, I turn to the solicitor's claim against the bank based on contract or negligence. We are here concerned with the general relationship between a bank and its customer in the common case where the latter has a current account with the former which is in credit. And that's also the position here. The underlying basis of this relationship is that it is one of debtor and creditor. The money deposited with the bank becomes its own. It is prima facie bound to meet a debt when called on to do so. And then we get a passage from the Hilton case, Lord Atkinson. And then at C, indeed, any failure by a bank to honour its customer's instruction may well redound to the serious discredit of the customer himself. On the authorities, it's clear that at least in the last century, the terms of a customer's mandate to his banker in respect of his current account were sacrosanct. And then we get the Vice Chancellor in the Bodum case. Let us see, therefore, what was the position of the bankers in the matter. I entirely agree with many of the observations that have been made by counsel for the defendants, that as between banker and customer, in a naked case of banker and customer, the banker looks only to the customer in respect of the account opened in that customer's name. And whatever checks that customer chooses to draw, the banker is to honour. He is not to inquire for what purpose the customer opened the account. He is not to inquire what the monies are that are put into that account, and he is not to inquire for what purposes monies are drawn out of that account. That is the plain general rule, as between banker and customer. And then we can go to the page 1354. We see a reference to a deed to Selingall and Karak rubber, which I'll come back to later on. And then 1355, just above F, where Mr. Justice Ongo Thomas turned to consider the claim against the banks in Selingall based on negligence. He said at 1591, a further and alternative claim is made against the defendant banks for negligence. This is a claim for damages at common law, as well as against other defendants, to replace monies misapplied as trustees or constructive trustees. Both these equitable and common law claims, as against both defendant banks, involve the allegations they ought to have made inquiry. Such allegations, though, differing in the case of each bank, are identical under both the equitable and common law claim, and its common ground that any standard of care which puts on inquiry or notice is the same under both claims. In my opinion, whether it is by concession or not, it is wrong to equate the duty to inquire where there has been a fraud and the bank is proved to have known of it, with that where all that is being alleged is the bank has been negligent. Nor was it necessary to rely on such equivalence in order to decide the issues in the Sellinger case. It was because of this error, I think, that both Mr. Justice Ongo Thomas in Sellinger and Mr. Justice Brightman in Crack Rubber stated the common law duty of care on a paying banker in the normal case of a current account and credit too highly. The relationship between the parties is contractual. The principal obligation is on the bank to honour its customers' cheques in accordance with its mandate on instructions. There is nothing in such a contract, express or implied, which could require a banker to consider the commercial wisdom or otherwise of the particular transaction. Nor is there normally any express term in the contract requiring the bank to exercise any degree of care in deciding whether to honour a customer's cheque, which his instructions require him to pay. In my opinion, any implied term requiring the banker to exercise care must be limited. To a substantial extent, the banker's obligation under such a contract is largely automatic or mechanical. That comes back to the execution point I made a moment ago. Presented with a cheque drawn in accordance with the terms of that contract, the banker must honour it, save in what I would expect to be exceptional circumstances. And then at E, we get, for my part, I would hesitate to lay down any detailed rules in this context. In the simple case of a current account in credit, the basic obligation on the banker is to pay his customers' cheques in accordance with his mandate. Having in mind the vast number of cheques which are presented for payment every day in this country, whether over a bank counter or through the clearing bank, it is, in my opinion, only when the circumstances are such that any reasonable cashier would hesitate to pay a cheque at once and refer it to his or her superior, and when any reasonable superior would hesitate to authorise payment without inquiry, that a cheque should not be paid immediately on presentation and such inquiry made. Further, it would, I think, be only in rare circumstances, and when only any reasonable bank manager would do the same, that a manager should instruct his staff to refer all or some of his customers' cheques to him before they are paid. In this analysis, I have respectfully derived substantial assistance from the material parts of the judgment in Quince care. So that's
the reason that we have that passage, the one you've just read, is from E to H, is because of the concessions made by Mr. Sumption on behalf of the bank between C and E.
yes, that's right.
He accepted that it couldn't be an absolute rule,
Correct.
and then talked about what the limitations on it might be.
Correct. And he talks about could only arise where the transaction on its face was dishonest. So again, that's a question about the instruction. So that's Lord Justice May, and then Lord Justice Parker. We can pick up at 1372. Just on the way there, let me just pick up one point my friend Mr. McElroy made on 1361. He talked about the facts at the foot of 1361 and the three payment mechanisms. And he said if the money had been transferred to a spoof account, then it would be remarkable if the customer had no right of recourse. But with respect, in that situation, the Quince care duty would still arise because the authorised signatory is acting in fraud of the customer in transferring money to the spoof account. Where the problem arises is when the fraud is outside of the banker-customer relationship.
You say that the bit about, which was from that decision in 1850 something, that banks don't have to do various things. That's not the case anymore.
That's obviously got to be looked at in the context now of the money laundering regime, the regulatory.
Whether your client likes it or not, it does know lots of things which that judgment said he didn't have to.
From a regulatory and point of view, yes, I agree. But the bank now has to do lots of things as a matter of regulation and as a matter of legislation. But that's a different question to.
I understand, but just to complete the thought, the point is that
So then Lord Justice Parker is at page he starts at page 1360, but we can pick it up at 1372. Where we get the heading, the solicitor's claim against the bank. Well, all the checks were within the bank's mandate.
Sorry, what page?
Sorry, 1372 at B.
1372.
1372B.
Yeah.
All the checks were within the bank's mandate, and there being funds to meet them. The bank's primary obligation was to honour them. Such obligation is, however, not absolute. It's common ground that in some circumstances a bank would, notwithstanding it honoured a cheque duly signed by a person whose signature it was authorised and required to honour, nevertheless be acting in breach of contract. An extreme example would be where the bank in fact knows a cheque is being drawn in fraud. Now I'll stress those words, being drawn in fraud, because by definition it's being drawn by the authorised signatory. In fraud of the customer, or what amounts to the same, they turn a blind eye to the obvious. He's talking there about, when he talks about being drawn, he's talking about somebody within the customer, rather than, as it were, fraud being on the part of the payee. He's talking about drawing in a cheque sense, if that's the way, put it that way. And then on to 1376, we get the heading, the law. He says that a bank has a duty of care to its customer when carrying out its mandate. That a bank has a duty of care to its customer when carrying out its mandate is beyond doubt. But so to state advances matters but little, for in each case the question for decision is whether a bank has failed in that duty. And there are very many cases on the subject, a considerable number of which were cited in argument. In my view, such cases must be approached with caution, for essentially they are no more than decisions of fact, i.e. the application of the law to an endless variety of circumstances. Expressions in them, such as the paying bank must pay under its mandate, save in extreme circumstances, such extreme cases, or that a bank is not obliged to act as an amateur detective, or that suspicion is not enough to justify failing to pay according to the mandate, or other like observations, which are to be found in the cases, are no more than comments on particular facts or situations and embody, in my view, no principles of law. And then we can come down to the letter G. Finally, it's to be noted that the distinction between liability as a constructive trustee and liability for breach of contract is frequently blurred or unconsidered. For the above reasons, it would not, in my judgment, serve any useful purpose to embark on an analysis of the many authorities cited. And he then cites the passage from Mr. Justice Elliott, the first instance, which we saw picked up in the Quince case by Mr. Justice Stade, including the important words at the top of page 1377 about authorised signatories misusing their authority. And then Lord Justice Parker says beneath that quote, so far as breach of contract is concerned, the judge's approach was, in my judgment, more favourable to the bank than was justified if, as appears to be the case, he considered that some want of probity was required even to establish breach of contract. Mr. Sumption had not so submitted, nor did he so submit before us. If a reasonable banker would have had reasonable grounds for believing that Cass was operating the client account in fraud, then he continued to pay the cash cheques without inquiry, the bank would, in my view, be negligent and thus liable for breach of contract. He then refers to the Nearhall case, which was a case concerning a claim of dishonest assistance against the bank as well as various trustees who operated the trust account held with the bank. And over the page, 1378, Lord Justice Slade was there considering a case based on constructive trusteeship, not breach of contract. But to a great extent, his observations are, in my judgment, equally applicable to a claim based on breach of contract. I would not, however, accept that the bank could always properly pay if it had reasonable grounds for a belief falling short of probability. The question must be whether, if a reasonable and honest banker knew of the relevant facts, he would have considered that there was a serious or real possibility, albeit not amounting to a probability, that his customer might be being defrauded, or in this case, that there was a serious or real possibility that Cass was drawing on the client account and using the funds so obtained for his own and not the solicitor's or beneficiary's purposes. That, at least, the customer must establish. If it is established, then, in my view, a reasonable banker would be in breach of duty if he continued to pay cheques without inquiry. And then at the end of that passage alongside D, he says, in the present case, the inquiry is simply whether Mr. Fox, and therefore the bank, had on the basis of the facts and banking practices established at the time, reason to believe there was a serious possibility that Cass was misusing his authority to sign under the mandate, in order to obtain and misapply the cash handed to Chapman in fraud of the solicitors. So again, we say that's a case that's all to do with an internal fraud, and the references to on inquiry are in that context. Now, following Lipkin-Gorman, the Quince care duty found itself gathering dust in some quiet corner of the common law, from which it only emerged about 25 years later. And we would say that itself is instructive, because it serves to highlight its narrow application, a point which we'll see is stressed in some of the later cases. Now, its return to the fray took place in a case called Singularis, which is in the second volume of Authorities at tab 24. And at first instance, the claim was tried by Mrs. Justice Rose. And perhaps if the court could just read very briefly the facts set out in the head note.
You want us to look at Mrs. Justice Rose, do you?
To start with, please, yes. Tab 24. So again, this is an internal fraud case. S was acting in breach. S was acting in fraud on the claimant company, which S wholly owned. Now, this in fact is the only case in which a claim for breach of the Quince care duty has succeeded. And as my own friend Mr. Sims said this morning, a lot of the judgment, in fact, I don't think he took you to Mrs. Justice Rose, but a lot of what this court and the appellate court had to consider was the question of attribution.
It's about attribution.
Which obviously we don't need to concern ourselves with.
It's the battle between Stoner Rolls and Belter.
Yes, right. But there was nonetheless quite a examination too of the Quince care duty, and we can pick it up at page 1430 in Mrs. Justice Rose's decision. Where we see the heading just alongside E, the claim in negligence, the scope of the bank's duty under Lipkin-Gorman and Quince care. Now, interestingly, Mrs. Justice Rose started with Lipkin-Gorman and then went to Quince care, but you see that at 163 she refers to Lipkin-Gorman, then over the page 168 she then deals with Quince care, or refers to Quince care. If we then go on to page 1436, paragraph 184, and this we say is a critical paragraph. The issue for the court in this case is therefore whether in the context of a claim by the company against the bank for breach of the Quince care duty, the director's fraud should be attributed to the company in order to defeat the claim. In my judgment, it would not be right to do so, because such an attribution would denude the duty of any value in cases where it is most needed. The duty is only relevant, underline the words only relevant, in a situation where the instruction to pay out the money are given by the person who's been entrusted by the company as a signatory on the bank account. So the duty is only relevant where there's a authorised signatory situation. If there were no properly authorised instruction to transfer the money, the company would not need to rely on the Quince care duty. The existence of the duty is therefore predicated, I cannot stress that word, on the assumption that the person whose fraud is suspected is a trusted employee or officer. So the duty is predicated on there having been an internal fraud. So the duty, when it arises, is a duty to save the company from the fraudulent conduct of that trusted person. And then going on to page 1446, at the top of that page, by letter A, he says the balance between the competing interests, this is 1446, the balance between the competing interests of a customer and the bank as the two victims of the deceit is struck here by the carefully calibrated, again I'll stress those words, they're words that are picked up later on, carefully calibrated threshold of the Quince care duty, taking into account the factors that were discussed by the judges in Lipkin, Gorman and Quince care. It would not enhance the integrity of the law to undermine that balance by denying the claim on grounds of illegality in a case where ex hypothesi the exceptional circumstances needed for the duty to arise and to be breached are found to be present. Now, the Court of Appeal's judgment is behind the next tab, and the sole judgment was given by Sir Geoffrey Ross as the Chancellor. Here, the relevant passages start at 2788. Where he as the heading authorities relating to die was duty of care, and he starts actually the other way round from Mrs. Justice Rose. He puts Quince care first, and then 35 Lipkin Gorman, and then page 2800. He cites the passage that I've just read from 184. Including the language of predicated and only relevant. And 57 respectfully agrees with that passage. And then going on to paragraph 66, we can see that Sir Geoffrey picks up in the fifth line the language used by Mrs. Justice Rose of carefully calibrated Quince care duty. Line of paragraph 66. And then on to 71.
Speaking for myself, Mr. Goodall, careful calibration of Quince care duty doesn't seem to have anything to do with this, because that's to do with the standard of reasonable banker. That's the calibration that's going on in Quince care. So I don't understand. You said it twice now, and I'm missing the point if it's important.
He's talking about there with respect, or not, the narrowness of the duty when viewed in the context of effectively the second duty as I put it. In other words, he's saying the second duty is to exercise reasonable skill and care in and about executing the instruction. As it were, the careful calibration comes in the sense that the Quince care duty itself is tied to an inquiry in relation to that execution of the instruction. In other words, working out is that really an instruction the customer
To me, what careful calibration is talking about is the bit originally in Quince care where you look at saying, well, we can't go this far, but we mustn't go too. There's a balance between going too far and not far enough, and the judge prompts for a carefully calibrated middle ground. That's what I thought this was talking about. It doesn't seem to have anything to do with what you're saying. It's got something to do with the fact that the origin is to do with the authorisation.
Well, obviously Mrs. Justice Rose had used that that language in para 218, and she had then, as it were, tied it back to the exceptional circumstances needed for the duty to arise. So that's why I had understood, perhaps wrongly, but I understood the careful calibration to be tied to the exceptional circumstances. And that's the source, as it were, of the careful calibration language. So that was para 66 in Court of Appeal. 71 of the Court of Appeal, Sir Geoffrey then in the sixth line identifies the Quince care duty, and he quotes from Mr. Justice Dane, as one to refrain from executing an order if and for so long as the banker is put on inquiry. And then I think we can go on to para 86. He says, in my judgment, this case can be decided on a more straightforward and well-established basis. It's true that the court must always have regard to the scope of duty of care that is relied upon in any particular case, but the scope of the Quince care duty is narrow and well-defined. It is to protect a banker's customer from losing funds held in a bank account with that banker whilst the circumstances put the banker on inquiry. And when he's talking there about losing funds, he's talking there about the authorised signatory, as it were, plunging the account. He's not talking about the customer losing funds because they decide to make the transfer.
Well, that's because, again, it wasn't part of the facts of the case.
I mean, isn't he just talking about what he said, losing funds? Because it's about the balance between you've got two innocent people that where's the loss for? I mean, which is back to the...
Well, with respect to, because he's identified that the Quince care duty is narrow and well defined, and because, as Mr. Justice Rose has said, and indeed he's endorsed, it's predicated upon there being an internal fraud and only relevant in those circumstances. The only way of reading losing funds, I would respectfully suggest, is he's talking there about the company losing funds because the authorised signatory is acting in fraud of the company. He's already said earlier on the only circumstances in which Quince care can arise is where there is the authorised signatory position. And then paragraph 88, alongside the letter E, page 2808. The duty is a binary one, to stop payments from being made out of the customer's account in certain very limited circumstances. And then I think we can pick it up in 98, which is the conclusion where he draws it together. And he says there are certain general conclusions that I think, properly be drawn from this case, put into a rather broader context. First, we were told by Mr. Miles, this is the first case where the court has found against a bank in respect of the Quince care duty. That is because it will be a rare situation for a bank to be put on inquiry. There is a high threshold. But here the judge found, as I've already said, that any reasonable banker would have realised there were many obvious, even glaring signs that Mr. Al-Saini was perpetrating a fraud on the company, which he instructed that the money be paid to other parts of his business operations. This case is therefore an unusual one, the circumstances of which are unlikely often to arise. Secondly, Daewoo has sought to rely at every level of its argument on the existence of a prior fraud as a reason why it ought to have a successful defence. But this ignores the fact, mentioned several times already, that the prior fraud is itself an essential ingredient of the claim for breach of the Quince care duty. Thirdly, Daewoo has sought to suggest that its liability is inappropriate, because it's more onerous than that imposed on an auditor. But as the judge held, and I have reiterated in this judgment, there is no proper comparison between the duties of auditors and bankers. A banker's duties in respect of properly authorised instructions to make payment are strictly limited. As the passage I've cited above from Quince care and Lipton Gorman show, the banker's duty only arises where abnormally the banker is put on inquiry by the particular circumstances. as Mr Justice states in the Quince case, trust, not distrust, is the basis of a bank's dealing with its customers. And full weight must be given to this consideration before one can conclude that the bank had reasonable grounds for thinking that the order, again I'll stress that, was part of a fraudulent scheme to defraud the company. He continued by saying that the law should guard against facilitation of fraud and exact a reasonable standard of care to combat fraud, protect bank customers, innocent third parties. I respectfully agree. Now
So the confusion
sorry.
at the moment
Yes,
is
sorry.
very-
Yes, sorry. Yes, my lord.
Right, 10:30 tomorrow.